Good morning to you all, and welcome to our webinar this morning. For those of you who don't know me already, my name is Ian O'Herlihy, and I'm head of the Education Department in Mason Hayes and Curran. This morning's webinar has really grown out of a series of webinars that the Education Department has put on for the education sector, particularly the primary and secondary sector, since the original lockdown almost a year ago. We've run a lot of webinars for primary and secondary schools, and a couple of our third level clients who knew about those webinars have come to us and said, look, why don't you actually run some webinars for third level colleges on some of the, if you like, hot topics or current issues that third level colleges face from time to time. So that's what we've decided to do. And this is the first of a number of webinars that we're going to run for third level colleges on a monthly basis. So for example, at the end of March, you'll get notification of a webinar on a different topic altogether, crisis management and communications in a crisis for third level colleges. And we'll be partnering with an expert in that area, Owen McDermott of the Communications Clinic. And at the end of April, we'll be running a webinar on academic appeals, the do's, the don'ts, how to keep yourself out of legal difficulties and judicial review and all that sort of thing. So today's webinar is really focusing on how to handle complaints, with a particular focus on student complaints. And I'll talk about that in a moment. Can I kick off firstly by introducing my colleagues, Liz Ryan, Paul Rochford, Fiona Shield, and you'll be hearing from all of those as we go through this seminar, because we'll be talking about different aspects of the topic. And we're approaching today's topic really looking at all types of complaints that involve a student. So we're looking at complaints by students against other students, complaints by a student, for example, against a staff member. Also, we have advised third level colleges in relation to complaints of staff members against a student or students. So the common theme is students. And of course, we know and readily acknowledge that there are differences in how you deal with some of those complaints. There may be different policies, and Liz will be talking about policies and procedures and things around that in a couple of minutes. But there are also common issues that apply to all of those complaints. And so we'll be talking, if you like, about the common issues and trying to then distinguish between what the differences are depending on the nature of the complaint. One of the issues that are one of the problems that recurs quite often in relation to dealing with complaints in third level colleges is delay on the part of the colleges. We come across situations where colleges are criticized, and sometimes rightly criticized, because they have delayed, they've taken too long. So hopefully some of the guidance we give today will assist colleges in processing complaints, because our experience is that sometimes colleges are not sure how to handle some particular aspect of an investigation or a complaint. And the default position for everybody, lawyers, everybody else, is that when you don't know what to do, the default position is that sometimes you can end up doing nothing. And that is a difficult situation to defend. And just another fault that fault's not a right word, but another kind of a trap that sometimes third level colleges fall into is that they are confronted with some difficulty, perhaps put up by one of the parties or one of the parties' representatives. And they're not sure what to do, and they're looking for a no-risk option. And in many cases, we end up advising the college that there is no risk option. But sometimes a person in a college is concerned, like, oh, am I going to be criticized by the college president or something because there's a threat of legal action or something. There sometimes is no risk action, no risk option, and you just have to make a choice to proceed along the best course of action. Lastly, before we get into the kind of the meat of today's topic, I just want to kind of outline the kind of approach that we're taking. We're dealing with the topic today basically in the same sequence that a college might deal with a complaint. So Paul is going to start off by dealing with some of the preliminary issues, including have you got a complaint at all, and also some of the issues that arise at the very beginning. Liz is going to focus on your policies and procedures and some codes of practice that kind of will steer you on how you do and how you process a complaint. I'm going to be looking at, if you like, things like investigations and hearings, the do's, the don'ts, the tripwires around that. And lastly, again in the sequence, Fiona is going to be looking at sanctions, the do's and the don'ts about sanctions and some of the trips that we want to try to avoid. So I'm going to start with Paul, and I said he's going to deal with some preliminary issues. Paul, one issue that sometimes comes up is, do you have a complaint at all? Somebody has come in and they're given out about something that somebody has done. Can you talk to us about that for a minute?
Absolutely, Ian. Thanks, and good morning to everybody. Yeah, it's very important to kind of establish that the complaint has actually been made, and sometimes that can arise from a confusion, but either on the part of the person receiving the receiving end of the communication or the person giving it. And sometimes that arises because, for example, in the case of students, they may not be used to the formality of what's required in relation to a complaint. So they may come in reporting something that has happened for other reasons, because they're looking for support, they're looking for, pastoral care or whatever. And you may have to actually put it to them, well, is this something you want to make a complaint about? And in terms of what you were talking about in the progressive nature of what we're talking about this morning, if you think about it like a journey, establishing the complaint or whether a complaint is there is the starting point of the journey. And from that starting point, then you decide what map you're going to use in terms of what policy. So if it's a complaint that comes under the dignity and respect policy, well, that's the map you have to follow. But if you're not sure of that and you're not using the right map or right policy, then you get halfway down the road and you have to turn back. And that is the problems that you were talking about in terms of delay. And it exacerbates then the risk exposure you have because maybe you haven't dealt with something properly or haven't done something properly. So, is it a complaint? Where does it lie under? And the other thing then is, if it is a complaint, is it a complaint you can deal with? So you may have a situation where a complaint arises out of some other interaction outside of the college. So if a student is on a placement somewhere, or if an employee is on secondment with another institution, something may have happened there that gives rise to an issue. You should be aware of it and you should support your student or your member of staff, but the actual dealing with the complaint and the investigation of it may need to be done by that other entity, and you should be very clear about that and communicate that clearly to the person.
Thanks. That's helpful, and that really leads into another question, and that is that, okay, you've established maybe that there's a complaint and it's a complaint that college may have to deal with. Are there any circumstances where there are sort of preliminary inquiries to be made of some kind before you get into, if you like, an investigation proper?
Yeah, this often arises, and again, because people come forward with things for different reasons, and they may not be fully aware of the level of information that's needed to initiate a formal process, or even an informal process for that matter, as some policies will have. But you need to establish certain basic things. The parties involved is alleged to have occurred, the timing of it, when it was alleged to have occurred. So you need those basics before you can even initiate any kind of process. So you may need to ask some questions of the person making the complaint on a preliminary basis. Now, an ideal way of doing this is to get the complaint in writing from the person. And most policies should have something in there that says a complaint should be in writing, and that's the ideal scenario, because you encourage the person to capture all the relevant detail of the complaint in a document. You know, it doesn't have to be, it can be a form, or it can be just a handwritten or typed narrative. But what it does is it establishes the four corners of the complaint at that point in time, which then forms the basis for your process. And if 6 months down the road, when you're reaching the conclusion of your process, the person says, oh, wait, no, you didn't look into this. Well, you can go back and say, no, that actually wasn't part of your complaint. So if you want to make another complaint now about that, then that's fine. We can deal with that. But that's, we haven't actually missed something, because here's what you complained about in the initial stage. The thing you need to be careful of is not to overdo it. So I had a situation recently where a complaint was made in an employment context, and they needed more details. So two people were from the HR department were tasked with going off and conducting a preliminary kind of gathering of facts to enable a complaint to be kind of articulated properly under the policy. And what they did was, with the best of intentions, they went off, they interviewed people, they took notes, they took evidence, and they arrived back to the HR director with a 35-page report, which unfortunately arrived at findings as well. And this created huge difficulty, and they were very unhappy with me when I said to them, look, you're going to have to scrap all of that and go back and start again. But that was what had to be done. And again, gave rise to delay. They then had to go and explain to the complainant and the person complained about why there was now this report that was going to be discarded and not used, and did that cause problems? So you need to give very clear writing instructions to people who are going to engage in that kind of activity, what is required and what should not be done or is not required.
And that's, I think, very important, if you like, at the get go. And I've often heard you and others on the education team kind of commenting to clients, you know, you can't investigate a complaint in general terms. And I think what you're really saying is that's why you need stuff you need a complaint in writing, and it needs to be detailed if it's going to be investigated. Here's a tricky one. Suppose you get a complaint coming in your door that complains about conduct on social media. What are the challenges there?
Well, there are challenges, Ian, and it's such a ubiquitous part of our life now. You know, everybody, social media, almost every day, and the extent of the things that we're sharing now has expanded hugely, and that is particularly the case, I would say, amongst young people and people who are going to be students in third level colleges. And you know, we may have you know, some difficulty understanding some of the things they're sharing, but that is where they spend a huge portion of their life. So you have to consider the context of what that is. So the first step in doing that, I would suggest, is that you should have a social media policy, and have a clear one that sets out what the expectations are of students and staff when they're on social media, whether that be on official social media using a college account or address, or their own accounts, but where they're discussing stuff to do with the college. And that policy should set out what behaviours are not acceptable. It should link to your other policies that Liz is going to talk about in a while, and make clear what the link is there where there's going to be a breach of that policy by that behaviour online. And then the other considerations come into play. So, you know, somebody may find something objectionable on social media, but it may not be something that's complainable, you know, or can be raised as a complaint under one of your policies. They may just not like it and may come to you, and you'll have to explain to them, look, that doesn't fall under the policy. Or it may be something that is outside of the life of the college altogether. So, you know, it may be objectionable behaviour, it may be behaviour that if it was related to the college would breach the policy, but it's not about the college. It just so happens that they are a student or they are a member of staff and they've said or done this thing or shared this thing. And then the other kind of element you have to consider in relation to social media complaints is whether you need to look externally in relation to the behaviour complained of. So certain behaviours now, as of very recently, are criminal offences in terms of the sharing of certain intimate images without consent. So that is something that needs to be considered and factored into your decision making. And then there are also mechanisms within the providers of the various social media outlets about complaining within their mechanisms about the content or having it taken down if somebody wants something objectionable taken down. And depending on the context and who it is, you may want to consider what supports you provide to the student or member of staff in terms of assisting them with that if you're going to do that. So there are a couple of different considerations in relation to it. The thing about social media is that it's a very immediate and a very high pressured setting. So you're going to be under a lot of pressure to do something very quickly. And I would suggest maybe you just take a moment to pause and make sure you're doing the right thing in relation to it rather than just doing something. But so those, a lot of different considerations there in relation to social media.
And I think one of the things that social media has changed to some extent is, you know, the traditional approach that colleges might have taken, which is if some conduct occurred literally outside the college, it's nothing to do with us. And basically social media has, if you like, blurred that inside outside college. And it's something that you were saying your policy really should address and make and so that students know where they stand. Here's another tricky one. Sometimes anonymous complaints. Any guidance around those?
Yeah, anonymous complaints can cause real problems, and you know, one of the reasons that they cause those problems you were going to touch on later on in relation to the whole issue of fair procedures and natural justice. So, you know, somebody comes in and makes a serious allegation about another person anonymously, and that person about whom the complaint is made is entitled to defend their good name. They're entitled to, you know what is being alleged against them. They're entitled in certain circumstances to challenge that person in relation to the allegation they're making and the evidence they're putting forward. And when you have an anonymous complaint, none of that is possible. So that creates serious difficulties then in relation to it. And you'll see in a lot of policies, in a lot of organizations, they will say quite plainly at the outset, look, we can't deal with anonymous complaints for that reason. So they do create difficulties. There may be certain circumstances where you might want to consider progressing them in any event, you know, but those would be few and far between. For example, if you've got a multitude of anonymous complaints about a particular person, perhaps a member of staff, and you got you know, a dozen complaints from students who are linked to that member of staff in a lecture or whatever, you might want to consider, look, is this something we need to have a look at? Or you might have an allegation made anonymously where it's the nature of the complaint is it doesn't need an accuser. So there might be some allegation of some sort of wrongdoing where there is objective, independent evidence that can be sourced from records that you can set out the basis of the allegation from that. You don't actually need a live person to sit in a chair and make the allegation because you can go off and look at it. So very limited circumstances where you would consider it. I would say before you do, you need specific advice in those limited circumstances. But the general position would be, look, you can't progress it. So unless that person comes forward, you're left in a very difficult scenario.
Thanks, Paul, for that. And the last question for you is, suppose a complaint is alleging conduct that could possibly be criminal conduct. Have you any advice to give in relation to, for example, reporting to the Gardaí or involvement of the Gardaí? Anything around that?
So I think we're all a bit more aware of this. We'll all remember the trial in Northern Ireland a couple of years ago, where, you know, part of that whole issue of reporting to the authorities became part of the national discussion. And, you know, I think it's fair to say that there certainly seems to be more of a reluctance to report certain things now because of all the publicity that was attached to that particular trial. If you have something reported to you as a complaint that may constitute a criminal offence, then, you know, except in very limited circumstances, it's a matter for the person complaining of that conduct to make a report to the Gardaí. And certainly you should encourage them to do that, and you should support them in doing that. There are, as I said, limited circumstances. So one that may be of note to third level colleges is where you, as you will sometimes do, have somebody who is under 18, perhaps as a first year student. They are still categorized and classified as a child under the relevant legislation. Or you may have somebody who comes within the definition of a vulnerable adult. So somebody who has some sort of condition or different ability that brings them within that definition, but they're a student within your college. In those circumstances where there is a situation involving either of those two types of people, then there may be a legal obligation on you to report certain allegations or behaviour complained of under the relevant legislation. But other than that, the other main consideration you need to be aware of in terms of where the Gardaí get involved or don't get involved is how it impacts on your process. So very often the Gardaí will ask you to pause whatever you're doing until they complete their investigation and their file goes to the DPP or whatever. So that is something to be aware of. You need to know about that because the interaction of the two can be significant. Equally then, if the person doesn't make a complaint to the Gardaí and you're aware of that, well then you can push on and deal with your process as you would in the normal circumstances. But it's certainly a point you need to be aware of when you get to that more serious end of behaviours that are complained about. Thanks
for that, Paul. Okay, well, Paul has kind of addressed the preliminary issues. I'm now going to, and he's made reference, I suppose, to policies and procedures, which is something that we're going to be referencing throughout this webinar. I'm now going to go over to my partner, Liz Ryan, because she's going to particularly focus on policies and procedures, the do's and the don'ts, and she's going to refer to some strategies around that. So, Liz.
Thank you, Ian, and good morning, everybody. The subject matter that I'm going to cover, as Ian mentioned, is around the area of policies. And I suppose at the outset, it's worth bearing in mind that I'm going to focus on two particular policies. They are the bullying and harassment policies that a college might have in place. I'm not going to focus on other policies that might deal with other types of behaviour. I was interested when Paul spoke about pausing, and certainly in my experience, many employers, when they get a complaint, they tend to rush into triggering a process to deal with that complaint. And while no college wants to be accused or they want to have it leveled at them that they delayed in dealing with a complaint, it's a very, very good idea, both at the complaint stage and before you decide what you're going to do next, to pause and think about it a while. And I suppose building on Paul's content, let's assume you as a college have a complaint and you're satisfied that the complaint, you've got enough information about it, you've enough detail, you have scoped it enough to accept that it is a valid complaint and it's a complaint that you can deal with. Well, then what do you do next? I would suggest the next step should be that you review the complaint, and the first decision, and it's a very important decision that you should make, is does this complaint point to bullying or does this complaint point to harassment? Now that might seem like a very simplistic junction, but it's actually a very, very important one because many employers conflate bullying and harassment. And in very simple terms, and I'm sure you're very familiar with both concepts, but just for the sake of clarity, a person is harassed if they're the subject matter of unwanted conduct that violates their dignity, and that person is protected from discrimination. So a person can only be harassed if they fall under the protection of the 9 grounds of persons who are protected under our employment equality legislation. So they are people who would fall into categories ranging from your religious belief, your age, your gender, and of course, if the conduct is related to a person's gender, that's sexual harassment, disability, traveller community, sexual orientation, and so forth. So if the conduct points to the fact that it's unwanted and violates the dignity of a person who's protected on one of the 9 grounds, then the terrain you're in is that of harassment. If the behaviour complained of is repeated, it's unwelcome and it undermines a person's dignity, and I'm parsing the definition of bullying here, that's bullying. So it is important at the outset to figure out what landscape am I in? Is this a bullying complaint or is this a harassment complaint? Because you know, I had a case about 3 years ago where an employer got themselves into a terrible mire where a complaint was investigated over a period of about 2 years. And both the complainant and the alleged perpetrator had junior and senior counsel acting for them. And I really believe that the reason that that happened was that the employer was very muddled from the beginning as to what is the terrain that this complaint falls in and what process do I use to deal with it. And ironically, the employer in question had very comprehensive bullying and harassment policies, but actually didn't pull it out of the drawer at the very beginning and say, okay, what's our roadmap here? What policy should we follow? Is it our bullying policy or our harassment policy? And the end result of that was that the employer got themselves into a very long, drawn out, convoluted investigation that cost a lot of money and also a lot of management time. And I'm sure some of you can appreciate the amount of management time that goes into handling these complaints. So your policies are definitely a roadmap, but more than that, it's important to bear in mind, policies are admissible in evidence in legal proceedings. So if you have a complaint against you, which ultimately ends up before the WRC or the civil courts, if you didn't follow your own policy, you're in some difficulty and you're going to have to explain why that was the case. If you took the approach of, I didn't follow my own policy because I didn't feel it was fit for purpose, or I believed that it made sense to deviate from the policy, that's absolutely fine as long as you can explain it. But it does put employers sometimes on the back foot because they are forced into a situation where they have to defend not following their own policy, which isn't really a great position to be in from the get-go. What I always say to employers is policies are just policies. They're not contractual. They can be changed at any stage. They should be consistently reviewed. Where there's a change in the law or there's a case law that points to an employer having to review its policy. And at times, an employer might decide, you know what, our policy isn't up to date. And if that's the case, if the code of practice has superseded your policy, use the code of practice. Say, for this investigation, we're going to follow this code of practice, if that makes more sense in the circumstances. So don't be so concerned about dotting your I's and crossing the T's on your policy that you fail to deviate from the policy or use the actual originating code of practice where that makes sense. And just always record why you've done it so that later on in an investigation, if the question is asked, you'll be able to understand why that decision was taken. Now, obviously, as colleges, you're in somewhat of an unusual situation in that your cohort is made up of employees, contractors, students, and possibly others who work with the college from time to time in a consultancy capacity, or you could have students at a master's or a PhD level. So you have a very wide cohort of people to protect against being bullied and harassed. And it is important that your policies comprehend that whole population of people. There's nothing to stop a college having, obviously, a bullying and harassment policy that relate to its own employees. So complaints about employees from employees. But you can also amend and customize those policies to deal with complaints about students against students, obviously in conjunction with your student representation bodies, or where students complain against staff members or vice versa. But it is important to bear in mind that you really shouldn't have a one-size-fits-all policy because it won't fit all sizes. The types of complaints that you might have to deal with student against student might be very different from the types of complaints that you deal with where it's an employee against another employee of the college. So make sure that you have the requisite number of policies without having, dozens of policies, but you might end up having 2 or 3 policies, the backbone, all of which are the same, but which are customized in recognition of the fact that you have a very diverse population of people interacting with the college. I'm going to move on now to talk about the 2 codes of practice. And obviously, the code of practice is the starting point for any employer to design a policy around. So a policy is typically the code of practice, but customized for that particular employer. The codes of practice do comprehend that a person within employment can be bullied or harassed by a non-employee. So the policies call out contractors, suppliers, customers. They don't actually call out students. But again, there's nothing at all wrong with a college having a policy that treats the student as a non-employee but potential complainant of a bullying or harassment type of an issue. Also, to Ian and to Paul's point, the policies also absolutely comprehend that bullying and harassment can occur outside of work. So they can occur in work-related events such as conferences, training courses, social events that are linked to work. It is, though, generally essential that there is a linkage to the workplace in this event which occurs outside of working hours. Moving on to the policies then very briefly, they're quite comprehensive. They're on the internet, so I'm not going to go through them in a huge amount of detail. And the chances are you're very familiar with the codes of practice. I did want to tell you, though, that there is, since December of 2020, a very much revised bullying code of practice that I would recommend that you read. I'm going to pull out some of the points that you might need to take notice of, and points where the 2020 Code of Practice differs from the previous Code of Practice. The definition of bullying stays the same in the 2020 Code of Practice, but very helpfully, the Code of Practice gives some definitions as to what constitutes bullying, such as social exclusion or overly excessive monitoring of work. But what I think is really interesting about this code of practice is that it also gives examples of what are not considered to be bullying. And included in those examples are areas such as constructive feedback, performance management, or where there is a disagreement or a conflict arising between individuals. So this is a very clear signal to employers that if you get a complaint, which, for example, is about a person's, the way in which a person's performance has been managed, it may be indicative of bullying if the way in which the performance was managed was oppressive or very unfair or undermined the dignity of the person whose performance was being managed. But in and of itself, performance management doesn't automatically have to be treated by the employer as a bullying allegation. So I think that's really interesting. Also, to Paul's point, the policy clearly comprehends that bullying does take place over social media. And we all know that through apps, through social media, and through email and internet. So that's a recognition of the kind of culture that we're living in. The 2020 policy has two informal approaches, and you might have a read of those. I'd be interested in your comments at some stage if we get to discuss them again, but also there is a formal approach. The policy really does push mediation, and we're seeing this more and more from the structure and the mechanism in which the WRC operates, but also there's a general recognition that mediation, if it's effective, if it's well planned, if there's clear terms of references, if you've got a competent mediator, it really is the best way to resolve bullying complaints, because often bullying complaints are not about what's there in black and white, and sometimes the behavior complained of isn't easily distilled in writing. Sometimes it's very much about the emotion around a relationship, and mediation can be a very powerful mechanism for employers and employees and students and contractors to engage in to resolve those kind of issues. Very interestingly, and Ian will touch on this later on, after the formal stage, assuming a complaint gets that far, the investigator should not determine that bullying took place. The investigator should limit their findings to, on the balance of probability, whether the behavior complained of actually occurred. And any finding of bullying should be left to a disciplinary procedure, assuming the complaint moves as far as a disciplinary procedure. And obviously the benefit of that is that in the context of a disciplinary procedure, both the complainant and the alleged perpetrator are entitled to fair procedures. So in a sense, because that decision is not made until the disciplinary procedure, it does give employers more latitude in the investigation around being slightly more, having a less high bar of applying natural justice and fair procedure through the investigation process. So that's really helpful. I'm going to very briefly touch on harassment because there hasn't, unfortunately, been an update to the harassment policy since 2012. I think that's something that is not optimal. I think the policy should be reviewed. But as you're all aware, the 2012 policy provides for an informal and formal approach, and it does at the end of the investigation provide that a complaint is upheld. So it's more consistent with the pre-2020 bullying process, in that there is a finding that a complaint is upheld. So what I would say to you in summary about the policies is look at the code of practice, be very familiar with them, but don't be hidebound about them. Don't be hidebound in following them. Do what makes sense for your own organization, because third parties, whether it's a WRC or a judge, always appreciate a common sense approach. And in our experience within the department, most employers who trip up in the context of a bullying and harassment investigation do so because they either take an overly literal prescriptive approach to the codes of practice and their own policy, and they don't do what makes sense, or else they abandon them completely and run off and trigger the process without acknowledging and following their own policies. So finally, I would say to you, as with all policies, there is no point in having them in a drawer where nobody knows about them and shaking the dust off them when you get a complaint. They should be out there front and central. They should be communicated to the people who will be affected by them. So that's, your students, your contractors, your employees. Communicate the policies, communicate changes to the policies. That's the first point I would make. The second is ensure that everybody who engages in one of those policies is trained. So whether that's your contact person, whether it's your investigator, whether it's a nominated person, whether it's a person dealing with an appeal, train those people as to what their roles and responsibilities are, where they start and where they end, and what the expectation of the college is of those individuals. And as I said, and I keep repeating it, if you have a policy that you're happy with, follow your own policy. So I hope that session was helpful to you in just determining the do's and don'ts around bullying and harassment policies. I'm now going to hand you back to my colleague Paul, who's going to just commence the next part of the session.
Thanks, Liz, and thanks very much for that discussion about policies, and particularly some of those practical directions at the end, which I think will be very helpful to people listening. So we've talked about where we start, Ian. We've talked about finding the right map, which Liz has now laid out for us. Now the rubber is going to meet the road on our journey through dealing with these complaints, and we're going to talk about investigations. So I suppose, picking up from where Liz left off, you have your policy, it says what it says. Very often they will set out the requirement for an investigation before there's any hearing, whether that's in an employment context or in a student complaint context. So what are the things, or what are the do's and don'ts that colleges should be looking at when they're considering or commencing an investigation?
Thanks, Paul. And I suppose that's a big question in itself. I had a look at some of the policies and procedures on some third level colleges in the last week or so, and some of the colleges have good policies and procedures and make it clear, what an investigation is and is not. But some of them use terms interchangeably. They talk about an investigation, they talk about a disciplinary investigation, they talk about, what I would encourage colleges to do just for the moment is forget about the terminology and just maybe focus on two processes. One is a process which we describe as information gathering. Gathering the facts gathering the details of the complaint, gathering people's, input into them and statements and that kind of thing. The second one is a fact finding, and in some cases, a guilt establishing process. And they are really important to keep them separate and not to mix them up. Now, there were some HR people I know on this webinar, and they will be familiar with the so-called Lyons judgment. And that was a case where there was an investigation of bullying, where the matter was sent out to external investigation, where the policy and the procedure actually stated that the investigator will establish bullying, whether bullying occurred. or something along those lines. And regardless of what the policy said, the investigator took it upon himself to take on that role. And Mr. Lyons, who was the accused party, said, hang on a second, you know, this is an investigation. This is not the disciplinary hearing at which a sanction will or will not be imposed. But if it's established that I have bullied, you know, the disciplinary hearing, I'm a dead man walking, you know, and he succeeded in overturning the investigation and injuncting the investigation. So you don't want to get into that space. Now, Liz has spoken in terms of the code of practice that she mentioned. Liz has spoken about, you know, the investigation establishing that certain facts have occurred. The approach that the education team like to use in an investigation is, and it's the same sort of thing, is whether there's a case to answer. I like that wording because I think we can get our head around it. Now, sometimes it's termed, you know, is it recommended that it'll go on to a disciplinary hearing? That's the same thing. Is there a disciplinary case to answer here or not? And if there is, that kind of goes off to a disciplinary procedure.
I think a fundamental part of that, and we've already touched on it earlier in the discussion, and you will very often have it put in front of you when you start an investigation, particularly getting letters from solicitors of the person who's under investigation. They will talk about fair procedures, natural justice, constitutional justice, due process, all, you know, great legalistic terms. What do they mean, though, in reality, in practice, and when do they apply in these settings?
Yeah, well, I suppose, Paul, like, we could have an entire webinar in answer to that question, you know, so dealing with that issue in a minute or two is a real challenge. If I answer the second question first, when do they apply? We'll talk about what they mean in a moment, but when do they apply? And it's really important, getting back to the first issue that I have, that you don't make them apply or allow them to be applied during an investigation. Now, the High Court and the Supreme Court have said in a number of cases that you don't get natural justice at every stage of a process. You get it once. And that would be something, if you're going to get it at all, is going to be something that that I would really encourage colleges to ensure. It's also worth saying, you know, that the courts have also said that the extent of natural justice is to some extent dependent on the seriousness of the matter. So if you're charged with a very serious matter, and in particular, if you're charged with a serious matter, if you like, or accused of a serious matter, which has a very serious sanction, well, then the rules of natural justice in a fuller sense will apply. So we have dealt with colleges where somebody has been accused of, I don't know, playing loud music in their college accommodation, keeping everybody awake, you know, and they're facing a fine. And they have said, you know, I want a hearing and I want to, you know, bring in sound experts to measure the sound and decibels, and I want to produce witnesses. Now, forget about that, sunshine, because that's not going to happen. This is a fine. This is not a serious one. The person isn't facing expulsion, you know. So the extent of natural justice is something that can be related to the seriousness of the accusation. If, however, you have a serious accusation, and suppose, for example, somebody is accused of sexual harassment or sexual assault or something, which affects a person's good name and which may also very possibly lead to a very serious sanction. So if it was an employee, it could lead to dismissal. If it's a student, it could lead to expulsion, whatever it is. There is certainly an argument that natural justice rights should be afforded. There are two fundamental natural justice rights flowing from two Latin maxims. One is that you should be allowed to be heard in your own defense. And the other one is that you know, the decision maker should be unbiased. And obviously there are sub-principles in relation to the first one, heard your own defense. You have to, as Liz says, you have to be told what the accusation is. And in certain circumstances, limited circumstances, you may be entitled to confront your accuser. because we have had some people who have said that accusation is a lie, and if you allow me to confront the accuser, I will show you it's a lie. And if the accusation is very serious, they may be entitled to those sort of rights. So there's a judgment to be made in every case. Never forget about your own policy. And this is something I'm going to be coming back to in relation to some other questions you're going to ask me. That's relevant too, what your policy says. So it's a judgment in certain cases.
Okay, and one of the things that is linked to that, linked to what your policy says, linked to what goes on around an investigation, and something that we're seeing, I think, more often on the team is requests for legal representation at investigation meetings and at hearings. I had a recent request from or a query from a client where somebody asked to bring their solicitor to the annual performance review, which was, that's kind of demonstrates the extent things have got to at this stage. But is that something that a college must allow or must consider for an investigation or a disciplinary hearing? Well,
I'm getting back to the fundamental principles that we all keep saying. What does your policy say? That's the starting point. And the law has kind of traditionally been that the only time, unless your policy allows it, the only time that you might be allowed legal representation is when we get into one of these really serious accusations, serious sanctions. But the law has also changed with a court case that some of the HR people will be familiar with, the McKelvey judgment, which basically disallowed legal representation to somebody who was up on a serious employment disciplinary sanction, where the complaint arguably was in the sort of semi-criminal category of offence. And the Supreme Court said, you're not entitled to legal representation in that situation. And that is a pretty radical decision, but it's one that is very much in favour of institutions who do not want to allow legal representation, except perhaps in those very serious cases.
Okay. And one of the other things that we get asked about a lot, particularly recently, is in relation to cross-examination. And it's something that typically a complainant may be concerned about. Well, make this complaint, I'm going to have to sit in a room with this person. They've made a complaint, of sexual harassment or sexual assault. That's something that's of concern to them. So cross-examination, is that a blanket entitlement that people have in these circumstances, or how does a college deal with those requests?
Yeah, well, I'm like a record player stuck now, but the first, our starting point is your policy. Cross-examination is tricky. Again, you would not even be countenancing that except in the most serious cases. That is presuming that you're going to countenance it at all. There are practical issues, because if you have a complainant, for example, in a sexual harassment complaint, they may make the complaint, they may cooperate with the complaint, and we've had numerous cases of these for third level colleges, but the cross-examination by the accused party or the accused party's representative is a bridge too far, and they may say, I'm not coming to that. And indeed, you mentioned earlier on the case, the Ulster rugby case up in Paddy Jackson up in the north, and many students' unions have commented, if you like, that following that case, the chances of complainants allowing themselves to be cross-examined is pretty slim. So I would be reluctant. I can't say to you never allow cross-examination, but that's too absolute. But I would be very reluctant to allow it, except in the most serious cases.
Okay, and then one final question to put to you then is about the whole issue of confidentiality, which is kind of tied into those concerns that a complainant might have. I had an issue recently where a party requested the notes of disciplinary hearing and maintained that they had a right to those notes under the GDPR. What guidance would you give to colleges around that whole issue of privacy in relation to the documents and the records associated with an investigation and disciplinary process? Yeah, well, I suppose the real guidance, and we've all, on the education team, we've all
traveled the road on this as well, is to address issues around confidentiality of a process, confidentiality of notes, GDPR, upfront from the get-go. So that everybody who is being interviewed, who's making a statement, who's making a complaint, knows exactly what may happen with those notes. Bearing in mind, as a college must bear in mind that if college authorities have documentation upon which they may be relying in terms of applying a sanction, no surprise, the accused party usually entitled to a copy of those so that they can comment or respond. But we have found, particularly in recent times with GDPR and issues, that if colleges deal with stuff up front and people know where they stand, they will not get themselves into any great difficulties. So that's really our recommendation there. Thanks, Paul, for that. Now, I'm going to stop answering questions and maybe ask a question. I'm going to hand over to my colleague Fiona Shield. So we have kind of traveled, if you like, a route, and we are now finished with our investigation and our disciplinary process. We hope we've got through that, and we're now coming to decision stage and possible sanction if a complaint has been upheld. So Fiona, any do's and don'ts around decisions, sanctions? Talk to us.
Thanks, Ian, and hi, everybody. So yeah, as Ian said, I'm going to be wrapping up the session by dealing with sanctions in the case of students and employees. And I'm also going to briefly touch on the issue of appeals. And so my colleagues have already touched on this earlier, but sanctions can range from fines to verbal warnings to suspensions or dismissal or expulsion in the case of a student. And there are really two guiding principles which I want to talk to you about. So firstly, a sanction can only be considered when there has been a procedure and that procedure has been completed. So there has to be a finding that somebody is guilty, and that's really important to highlight. And if there has been that finding, you need to look at, well, has the correct decision maker under your policy came to that decision and imposed a specific sanction? So for example, if your policy states that it is the senior dean in the college who is the appropriate person to impose a sanction, was it in fact the senior dean who imposed the sanction? So, and I know this has been addressed already by my colleagues on the webinar, but it's just crucial to follow your policy correctly, because the majority of challenges which we see in the office relate to employers not following their own procedures correctly and skipping steps or abandoning their policy completely. And just also something to touch on here is the principle of proportionality, which you may be familiar with. So there's an expectation and in fact a legal entitlement that the sanction is proportionate to the action. So essentially the punishment has to fit the crime. So that's something to give careful consideration to. And if a student or an employee is potentially facing a decision with a sanction, they have to be warned of this in advance before they are called to a disciplinary hearing. So it doesn't come as a big surprise to them if there is, for an example, a dismissal or a suspension. And just on this point, where a decision with a sanction is being delivered, it's really important that reasons are given for the decision. So, for example, if a decision is made that an accused party is guilty of misconduct, the decision maker needs to communicate to the employee or student why he or she has found that the complaint is well founded. And just to touch on appeals briefly, if a sanction is imposed, a student or employee should be informed of their right of appeal and how to exercise that right. If an appeals process is covered in your policy, it should be clear to follow, and it's important that an appeal is dealt with by someone independent who hasn't been connected with the matter previously. And it's also worth noting that an appeal can be dealt with in writing. There doesn't necessarily have to be a full-blown appeals hearing, and we've seen appeals process in the past get abused where new issues are raised at the last minute. So it's just important to be mindful of that. And just to wrap up, I think that the takeaways from my piece are: don't ignore your own policy, and if a sanction is imposed, it has to be proportionate. And finally, no matter how justifiable you think it may be to dismiss or suspend a student or employee, you have to follow the appropriate procedures. So I hope you found some of my comments helpful, and I'm now going to hand you back to Ian.
Thanks for that, Fiona. So I mean, thanks for that, Fiona. So I mean, I think you've heard enough from us about policies and following them. As I said earlier on, really, it's impossible in sort of 50 minutes to deal comprehensively with all the aspects of the investigation of complaints involving students. I hope you've found what we've said helpful. Just to remind you that we have further webinars coming up at the end of March and April and maybe beyond. My office will be sending you a link after this webinar with a recording of the webinar in case you want to look at it again. And if there's anything that I or my colleagues on the education team can assist you with going forward, we would be very happy to do so. Otherwise, can I just say thank you for joining the webinar today, and I suppose I should wish you all good luck in dealing with any complaints that come in your door. Good morning to you all.